Well, several laws now need to be changed so that independent candidates can contest the elections next year. That's because the Electoral Amendment Act, which was signed into law by the President in April. But the devil's in the detail. Some of these still need to be ironed out before the election can actually be proclaimed. Michael Atkins is an independent elections analyst. He joins us now. Michael, good evening. So we have a new act signed into law by the President, supposed to allow independent candidates to contest for Parliament. The act criticised by many people. I think there are at least one, maybe two court challenges to it. Is Parliament still supposed to be looking at this at the moment, or is Parliament's role here done for now?
No, the Fundamental Act is passed and done, and we wait for the court's rulings. But there are what are termed consequential amendments arising from the presence of independent candidates in the elections. So, for example, the Party Funding Act, even the Electoral Commission Act, where they have party liaison committees, which clearly now need to be expanded to allow for independent candidates. They are technical amendments, but they are important for the conduct and for the build-up to the election.
We can't have an election without these amendments being passed. Is government moving quickly enough to do this?
Well, the matter has been discussed in the Home Affairs Portfolio Committee a number of times during 2022 and 2023, but there seems to be a slight delay. It was last discussed in the Portfolio Committee in June of this year. The committee is waiting for feedback or an update from the Minister, but essentially an Electoral Laws Amendment Act needs to be passed. The bill has not yet been presented to Parliament, and well, time is starting to tick by for elections next year.
As I understand it, the Constitutional Court will, in the end, have to rule on whether the new act is constitutional. Let me be clear, I'm speaking only for myself here. In my view, I can't see how they will rule it's constitutional. It seems to treat parties and independent candidates very differently and unfairly, in my view. So then if it rules against the act, what happens after that?
The sky actually probably doesn't fall in. I was involved in the preparation of those two court submissions, and the proposed remedies before the court allow for minor changes to the Electoral Act, the amended Electoral Act, which would allow the Act to proceed with independent candidates taking part, but with some of the worst aspects of the amendment having been ameliorated. So we probably don't have that all fall down scenario of needing to revert back to the original system.
Would it still be fair to the independent candidates, or would it just be less unfair?
The proposed amendments put before the court go a long way to removing the unfairness, for example, the high signature requirements or the high number of votes required by independent candidates to obtain a seat in the National Assembly. The proposals put before the court would go far enough to make it an even and a fair contest for independence.
Let me argue against myself for a moment, Michael, if you don't mind. Wouldn't that mean then that the court is almost legislating? So you're legislating from the bench. You'd be changing an act of Parliament without Parliament actually being involved. Now, it's one thing for the court to say what Parliament has done is unconstitutional, go and try again. Okay, that's happened many times, as we know. But to actually change the legislation, so judges changing the legislation, isn't that something different?
The matter was discussed in the court case in August. The arguments were raised, but there is precedent for a temporary writing in by the court of legislation or amendments to legislation, primarily in the interests of justice. So this has been done before in the recent past, and the court will have to weigh that up. You know, that is obviously in their realm rather than mine as an elections person. But there is precedent for this, and the possibility of it was aired openly in the court hearing.
There are other elements to all of this, and I suppose the next question would be, if that is what happens, and I think you'd be right, the sky wouldn't fall in, and I'm quite glad to hear the sky will still be with us next year, no matter what happens. Will people understand the system? Because it'll be a new system just before quite a contentious election, and it will involve independence for the first time. I realize there is a constitutional court ruling that says we must allow independence, and that must be correct. But it is also a big change just before a difficult election.
Yes, you're correct. The primary change is that there will now be 2 ballots for the National Assembly. In some ways, that mirrors the local government situation, except the constituencies, instead of being wards, localized wards, the so-called constituency ballot is a region which is a whole province. So it could well be confusing to people as to why they vote in a constituency that's a whole province and then separately for the provincial legislature. So it will be challenging both for the IEC, for political parties and for civil society bodies to get into some very good voter education in the build-up to the election.
And the Electoral Commission, as you say, I mean, they're in such a complicated position. They have to wait for the court rulings on all of this. I mean, that must be very difficult for them. If I remember correctly, I think the election has to be held by the 2nd or 3rd of August next year. The IEC would obviously want to go as late as possible if it needs to make these major changes.
Look, to be honest, there are not major changes. The first change from the court case would be just the seat allocation calculations for the National Assembly. Those numbers are put in right at the last minute anyway. There would be another small formula. It would take them a few weeks to resolve those queries. One of the major changes would be the signature requirements for independent candidates and so-called unrepresented parties. And that affects the build-up to the election. So people are waiting eagerly to see whether the signature requirements will be reduced.
Michael Atkins, really appreciate the time. Thank you. Independent elections analyst, as you can hear, of course, giving his view on the situation.